This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And as promised, we're joined now by Todd Lutsky from the law firm of Cushing & Dolan. The segment is Ask Todd. It's your chance to ask Todd your estate planning questions. Last week, I think we had either 4 or 5 callers. We got through 3 of them, so there's some urgency to make sure you're at the front of the line so that we can get to your call. Phone line is open at 888-205-2263. That is the studio number to speak to Todd Lutsky right now about your estate planning questions. Again, 888-205-2263 is the number to speak to Todd. We got the phone lines open and are waiting for you at 888-205-2263. Mr. Lutsky, how are you today?
I am never better. How are you?
I'm okay.
Just okay?
Okay-ish. Well, so I knew you were coming in today.
Yeah,
so
well,
I was talking to my wife about some estate planning stuff and was like, hey, I'd like to be cremated.
Yeah.
You know, seemed reasonable. She made an appointment for Tuesday.
So that's
a little earlier than I was hoping
earlier,
for. But, you know, this is what it is. Todd, I want to talk to you today about beneficiaries and basically the right and wrong ways to get assets to the people you want them to end up with. Let's say that I have a child who I want to inherit property, an investment account, whatever it may be. What is the upside and downside of me just saying, hey, I'm going to put you as a joint owner on a piece of real estate or an investment account?
Well, those are 2 very big, important differences in the type of assets you're mentioning. So real estate versus, or not real versus, but real estate and, let's say, a brokerage account. Well, let's start with the brokerage account because that one's easier. So this is why we do planning, right, folks? We don't just throw people's names on our accounts, although we do, but we shouldn't. And the reason we don't do that is when you add a child's name, as Chuck indicated, to a brokerage account, and let's say it's joint. Well, you haven't quite completed the gift yet. That's true because either party can go into a joint account typically and take out the money. So until the other party, the child, let's say, actually goes in and removes the money, that would complete the gift. Until then, you haven't actually made a completed gift. But to me, I'm scared enough just by the fact that the child could go in and take the money. So 1, that's a problem. 2, when you add a child's name to it, you've exposed that child's creditor. That child's creditors can now access half the account. So 1, I've exposed it to the kid's creditors, which I really don't like. Now, I can tell you the upside of doing that is, of course, when you pass, it will avoid probate and automatically go to that surviving joint owner. So I guess that's a positive. I don't think it is, but it's a positive. The real problem with that, though, is generally if you don't have just one child and you have, let's say, 3 kids, and this particular child happens to live close by, which is not uncommon. So for convenience purposes, you're thinking I'm going to throw this particular child's name on not only my brokerage account, perhaps, Chuck, but also the bank accounts so that they can what? Pay bills and help me out
Sure.
as I need it done. Well, if you've done that on 2-3 accounts and you have multiple children and then you die, well, that child likely is just going to get all those accounts, and you've disinherited effectively your other children, which you might not have meant to do. So, but you've done it. So, folks, that's just a few of the problems with it, but that's why I wouldn't do that. And of course, with real estate, it's even worse. You've completed the gift. You know, you exposed it to the kid's creditors. You can't sell it without that person's name. I mean, without the joint owner helping you, half the proceeds would go to that joint owner. I mean, just on and on problems with putting a child's name on a piece of property.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you have a question for Todd, this is your chance to ask him live on air. Studio line is open, still with some room on it at 888-205-2263. That is the number to call to speak with Todd Lutsky about your estate planning questions. Again, 888-205-2263. We're going to take a quick break here, but when we come back, it's going to be right to your questions with Todd Lutsky. Again, that phone number is 888-205-2263. One more time, it's 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
Still got some room on the phone lines if you'd like to speak to Todd Lutsky. We got plenty of space so that you can ask your estate planning questions. 888-205-2263 is the number. Again, it's 888-205-2263. Let's go to Carlene from Florida. Carlene, what's your question for Todd Lutsky?
I have an irrevocable trust, and my nephew is the trustee, and I would like to get an equity line. Is there any way that I can do that?
So, how long ago did you set this trust up?
Oh, it was in 2014.
2014. And your house, is this your primary residence that you put in?
Yeah.
Okay. And by chance, when you set this trust up and deeded the property into this trust, do you recall anybody using the word life estate, reserving a life estate for you?
That's what my taxes say. It says my niece and two nephews. It says I can't even think. Isn't that awful? SND, irrevocable. Wait a minute. I think I have it right.
Yeah.
SND. Does it say
Irrevocable trust.
Irrevocable trust of 2014, and it does. And above that, it says Colleen McLaughlin. That's me. Life estate, SND, irrevocable trust of 2014.
Okay, well, that's very helpful. Thank you. So, couple of things. When you reserve a life estate, it allows you not only to live there, but it allows you to keep existing mortgages if you had one when you put it in, which you may not have. But to get a mortgage now, you can try. I can't tell you the bank's going to do it. Every bank's different. But you're ultimately going to need the trustee of the trust to sign off and the life tenant to sign off on the mortgage. Okay? So you're going to need both. And I don't know that the bank will actually do that. So the one thing I always tell clients when they're setting up these trusts are, you can't borrow against the property without creating, without resetting that 5-year clock. So you're way beyond the 5-year Medicaid clock. So your house is protected. So you need to think about it. If you're doing this in the future, for everybody else listening, you reserve a life estate like Carlene did, right? But you get the reverse mortgage, or not the reverse mortgage, the home equity line of credit established before you create the trust. And that way, you then transfer the encumbered property to the trust, reserve the life estate, preserves the home equity line of credit, even though you may not have borrowed against it in 2014, in this example, when the trust was set up. But you established it. So now when Carlene says, I'd like to borrow, she could, because she would have already had the home equity line of credit with that life estate. And she could tap the mortgage anytime she wants, and it doesn't trigger the due on sale clause. But unfortunately, Carlene, it sounds to me like you did not do that prior to putting the property into the trust. So in order for you to get a home equity line now, likely you're going to have to deed the property out, or at least the remainder interest, out of the trust to the kids, nieces, nephews, whoever you plan on leaving it to, and keep your life estate. And then all of you could go to the bank and get a mortgage and not reset the clock. If you want to reset the clock, then you need to take the property out, get it to a child or a beneficiary, whoever's listed, and have them give it back to you, get your mortgage, put it in the trust, reserve a life estate. The downside with that is you're resetting your 5-year clock. Depending on how old you are, you may not want to do that. So it's a very good question, and hopefully that answered it for you. But folks, interestingly enough, it's a new month and we've got a new guide, and doing these life estates, which was the old month's guide, you kind of give up. It's a way of leaving assets to family members, but the guide this month is how to leave assets to beneficiaries, whoever that might be. What's the best way to do it? Is it outright? Is it staggered distributions? Do I want to control it for, the divorce-proof situation? Do I want to get it to a next generation estate tax free? Do I have children that are special needs? I mean, there's so much to think about when you're leaving your assets to your children, and this guide will get you there. So if you're starting your estate planning and you're thinking, well, how should I leave my assets? Get the guide, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Got another one for you, Todd. Let's go to Pam in Maine. Pam, what's your question for Todd Lutsky?
Well, it's exactly what he opened the show with. I was just at my daughter's place in New York, and we were going over everything. And there's just one daughter and myself at this point.
Uh-huh.
Don't anticipate there being any more. She does have a husband. And I have many assets over many different venues, approximately $1 million.
Okay.
But the house is the main thing for her. She's like, I don't want to sell my childhood home, and she doesn't want me to lose it, basically, to, in the event that I have to go into a home.
Yes. So, it sounds like the house is a big item, and it is for a lot of people. And so I think the type of planning that you would need to do to protect it for her, assuming you want to protect it for her. Again, we do what the client wants, not always what the children want. So I want you to know that you would be the decision maker. But if that is something you wish to do, yes, with an estate worth around $1 million and the house worth some portion of that, I absolutely would transfer it to an irrevocable Medicaid trust. Whether we reserve a life estate or not would be something we would determine then. Putting it in there is going to keep you in control. Can't get into every detail today, but you'd be 98% in control of that house. But 5 years down the road, if you got sick and went in the nursing home, it would be protected for your daughter, and then your daughter could live there, or you could control it through the trust for your daughter, any number of those things. So hopefully that helps a little, and yes, you're on the right track. That's exactly the way I would proceed.
Got one more for you, Todd. Let's go to David in Tucker. Is this Boston or Brewster?
Boston.
David in Boston. You're up with Todd.
Hi, Todd. Thanks for taking the call. Just a quick question. I'm single, and as I'm getting older, to avoid probate, what I want to do, I have a very close friend that I want to leave my 401k assets to.
Yep.
I'm going to leave my condo to my brother, but to avoid probate, my understanding is if I put that friend as a beneficiary, that friend will be able to have access to those assets provided he's able to get a certified death certificate.
So you're talking about the 401k?
401k.
Yeah. If you name a designated beneficiary at the 401k, they should be able to walk in to the institution. I suppose if they have a death certificate to prove that you're deceased, and then they'll show their driver's license so they know who they are, then they'll go pull the form, the designated beneficiary form that the financial institution has, and make sure it matches who's sitting in front of them. And if it does, I think that they'll be able to just take those assets. Not so easy, though, with the condo, right? What do you plan on doing with that?
Well, that I'm not sure just yet. But going back to the 401k, do I need a certified death certificate?
Yeah. Just get a certified. That's really the only kind you can get. Get him a certified death certificate, and he'll get it. He'll just go to the registry. He'll just go to the board there and pick it up. So yes. So I hope that helps a little, though. We gotta scoot, but yeah, the condo would be my only comment. Pay attention to the condo. Probably use a trust for that.
Mr. Lutsky, thank you so much for joining us today.
Oh, my pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.